Hello, everybody. Ava's there. Billy's big head's just blocking it. Hi, Billy. Yeah, hello, buddy. We're gonna go with blue buffalo turkey. Ava says, they're all good. Yeah, I came on just slightly early because all of them were around here. Tiny Kitten was right up here, and then all of a sudden I heard a and she bolted. She's in the tunnel now. But hello, Buzzy Pug. My. Hello, Mortimer Duke. Hello, Jerry Matthew Boyd. Hello, Wire Mother. Now I have to clean the crumbs off my desk. Hello, C-Rex. Hello, Nana Laura. Hello, Eileen and Carlin. Hello, Purple Kid. Oh, no. They're out to get you. Ava, you quit that. Hello, Shawnzy. All right, guys, there's something in the air. Several people have family members that are quite ill right now, and I just want you guys to know that I am praying for you. I see your messages, I see your Discord posts, and I love you all, and I love your families, and I just hope that everybody gets the care that they need and that you guys get the comfort that you need during this time. So, you guys know who you are, and you know I love you. Hello, Dark Zoomy. I've never heard of that. I have not. If it wasn't one of the oldies, those are what I know. I know the oldies, but not even really all of them. I'm a nerd, but I'm just not a super nerd, I guess. I'm sorry. I never really got super big into video games or computer games. I was talking with the guy that took me to my appointment the other day. He was from Nordicare, and he and I were discussing old video games. But he mentioned the Coleco, which I loved the Coleco. I actually named every guinea pig that I had that was calico colored. I named it Coleco. It's a web page based game. Well, then I've really never heard of it. I'm sorry. It was right after the Atari, and so many people never heard of it. Just like they never heard of the Jaguar, which was the original Doom. Hello, Jenny Green. Hello, Charlie. ColecoVision. Yes. Hi, Billy. What are you gonna sit on or knock down now? What troubles are you gonna get into? Yeah. What you gonna knock off my desk and then slap me with your tail with? That beautiful face. I love that face. You're so special. And the blimp. I've not heard of the blimp. I'm sorry. You got me there. You win. You win. I did not. I've emailed insurance and let them know there was a problem. I don't think I'll be ordering one myself. However, the guy at Ace, his name was Scott, he rigged up a lock nut situation to make it, and then he put a couple of nylon. What are you knocking over? Can you not? He rigged up a couple nylon washers and a lock nut situation to stop it. You don't need to get every single little cat kibble that they drop. You can wait. You have a full bowl of food. You have had treats. You've had way more treats than they even see. Get that pouty face off. Not gonna work. Quit knocking stuff off my desk or under my desk. Leave it alone. Excuse you. Cloaca? You know, the thing that birds use for going? I did not know that's a bird's anus. I didn't know. Unless you mean going like flight, but I don't think you do. Especially not on this channel. I miss Pac-Man on arcade. I had my neighbor over one night and we played Pac-Man for a couple hours on the TV. I have a Nintendo simulator game. It's got like preloaded a couple hundred Nintendo games and Pac-Man's one of them. And so we played for a couple hours, took turns getting our butts kicked. All right. I know. Nope. Mine pays 100%. I have Medicare and Medicaid, and I have another program called Inclusa. So it's 100% coverage. You, Mr. Peggy. Just open wide, Billy. Open wide. I'll pour them in. sprinkled some treats up on the cat tower for them to discover. I know, that's how she gets anything she wants. Anything and everything, and stays out of trouble. It's not that she doesn't get into trouble. It's just that when she does, she goes, and then I cave. Oh, it's the science part of the channel. Oh, I did not know. I did not know. And I don't know why. You know. With as much as my daughter is into birds, I'm gonna have to show her this part of the stream. And since she just won that art science competition with the Tiktaala, yeah, I'm so proud of her. Oh, that's amazing. She keeps getting emails from different parts of the university asking if they can post her design and her story and her success. And she's just over the moon. I'm so proud of her. She's amazing. Oh, oh my, oh my. A table game at the bar. PBR was involved. Sounds like a good night that you don't remember. Hemipene? I mean, from what I know of a hemi, sounds like a good thing. Too bad I'm not a reptile. Oh, yes. We didn't have arcade games in bars when I turned 21. By then, we had slot machines that were entertainment only, and they didn't pay out until you talk to the bartender. Yeah, Earl found his way in there. Tiny Kitten is in the kitty donut, in the gray one, because that was the quickest one she could dart into after hissing. I brought Bandit in and I showed her the magnificent cat tower that I built by hand, and I put her up on it, and it was all of 3 seconds before she saw Earl and just went into a hissing fit. And I mean fit. Oh man, she is just there's no the only way that they get along is when the door is closed and they don't see each other. But Earl is on the other side of the door, Bandit's on her side of the door. They'll both each be smelling under the door at the same time, and they're fine. But the second they see each other, Bandit goes ballistic. I don't know. I've tried feeding them, on opposite sides of the fence. I've tried, it just, he has traumatized her to next levels. Hello, Spider-Man. All right, guys. So tonight we have wood chipper fodder times 2. Yeah. Somehow this giant turd thinks he's the victim in all of this. And So they mention his charges at the end, and it is child content related. They don't go into graphic detail, so they just happen to mention that that's his charge, and they mention one thing that he did. So it's not extremely graphic. But he reads a letter to the judge, and somehow it goes from being addressed to the judge to him uncontrollably sobbing about what a great father he is, and like giving farewells to his family. I mean, it's hard to hear him through his blubbering, and you almost feel sorry for him until the prosecutor gets involved and speaks. Then you don't feel sorry for him anymore. But watch his attorney and the prosecutor lose their ever-loving minds. It's amazing. I can't wait for you guys to see it. Hello, Allison. Hey, it's good fertilizer. I know. Oh, I know. Just it's amazing. It's amazing how these people have the ability to paint themselves as the victim after the things that they do. It's gross. It's so gross. And that's, we love watching this kind of stuff because I don't know. I don't know why. I don't know why.
This is case number 2513693 FC People versus Eugene Jennings. He's here for sentencing today. Prosecution and defense was the pre-sentence investigation report timely available to you.
Yes, Your Honor.
Yes, it was, Your Honor.
And Mr. Brewer, have you the opportunity to read the report and discuss it with the client?
Yes, Your Honor.
Do you have any additions, corrections, or challenges?
No, Your Honor, I found it to be accurate.
Anything that you want the court to consider?
No, Your Honor, I just, no, Your Honor, I don't.
All right. Mr. Jennings, did you have the opportunity to read the report and discuss it with Mr. Brewer?
I had an opportunity to read the report, yes, sir. I received the report yesterday.
All right.
I have more about that in a statement I'd like to make.
Was the report accurate?
Is the report written from the perspective of my side or perspective of someone else's side, or like impartial?
Well, the narrative regarding the offense, that came from the police report. The other side of the things is it's Mr. Zerup's recommendation to the court. So,
Okay. It seemed accurate, yes, sir.
all right. Is there anything that you want the court to consider?
I do have a statement I'd like to read, if that's okay, Your Honor.
Yes, sir.
Do I stand?
Whatever is whatever you're more comfortable doing.
I'll stand for you, Your Honor. I apologize, I haven't read this with handcuffs on, so it might take me just a couple seconds. So I do apologize, I am going to have to sit down, sir.
Okay.
Because I haven't put it flat. Dear Honorable Judge Springstead, thank you for allowing me to address this court today, and thank you for presiding over this case, which I know must be stressful and unpleasant. My sincerest wish is that no one should ever endure any trauma or pleasantness due to the nature of these charges against me. Your Honor, before you issue your sentence, I would like to officially go on record as saying that I feel like I have been left without guiding light in this incredibly stressful and disastrous life-altering situation.
As far as you hope nobody has to endure, blah, 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 they've already endured it. You've already done the crime. You're at your sentencing. Stop it.
I feel like I've been stumbling around in the dark, figuring out stuff on my own or from other inmates more than anyone else. I don't believe that is fair to me, my family, or this court. During this time, when hearings have been scheduled, I've had no idea why I was going to court or what to expect. Sometimes I didn't know what a court date was for, if I even knew about it beforehand. My ex-wife got more information from the prosecuting attorney than I got from my own. She knew about my court dates changed in late December. That's how I found out. While people around me were getting character reference letters and writing letters to the judges, I had no input on any strategy for my situation whatsoever. I attempted to contact Mr. Greer at least 8 times after our first meeting and didn't hear from him for a month and a half. I was left completely in the dark. My sister was finally able to speak to him, calling from California, and explained to him how badly I needed help. He expressed that he needed to, quote, tighten his belt and start working on my case. This was 2 months after my arraignment. I finally got to meet with him a week later, and during this meeting, he was clipping his nails. He has told me several times in court that he would meet with me after a hearing and has not once visited me afterwards. I had to encourage him to watch the video where I supposedly confessed, explaining to him my history of mental breakdowns, anxiety, and PTSD, and the breakdown I had during the interrogation when my own childhood sexual abuse memories resurfaced. And he said, I'm sure you were stressed. Stress doesn't do my emotional state at that interrogation justice, Your Honor. The abuse I endured as a 6-year-old child resulted in several suicide attempts. The first when I was 9 years old and tried to hang myself with an extension cord in my backyard, as well as several attempts to run away from home. I finally convinced Mr. Greer to watch the video, and he completely dismissed my concerns and trauma, downplaying my situation, saying that there was no coercion, then asking me if I was taken to the mental health hospital after the interrogation, which I wasn't. However, I was put on a concrete holding tank for 7 days, told in nothing but a smock with no blanket, no pillow, and no mental health treatment to speak of. I have had through this whole process no advocate for my well-being, rights, or best interests. During our first meeting, he said that he needed to drop some charges and reduce some. Then later he told me it was getting reduced to 1 charge, but when I got to court, it was 2 counts concurrent. He asked me unnecessary questions in a later meeting, like, is your daughter your biological daughter? And others that demonstrated a lack of adequate knowledge of my case. I told him I wanted to fight my case so the facts could be heard, and he told me, quote, you're not the kind of father who would put your daughter through that. I asked him for a change of venue due to social media contamination of potential jury pool, and he flat out told me no, that fewer and fewer people are on social media these days. He assured me if I would just plead no contest, I would only get 25 years in prison, and I'm not confident that he can promise that. Again, I reached out to Mr. Gill several times before today's hearing, and no answer for over a week. Then with less than a week to go, 6 days in fact, I finally reached his secretary, who told me she didn't know if I needed character reference letters to write a letter to you, Your Honor, or to even review and sign my plea. She said she wasn't sure, but I might. She'd see him Sunday afternoon, less than 24 hours before the sentencing hearing. I had no idea what a PSI was until I received it, and got more input on my PSI from the investigator than from my attorney. I did, in fact, get to meet with Mr. Grigg yesterday at 11:05 a.m. when I was given my pre-sentence investigation report for the first time with no opportunity to review, revise, or dispute any of it. Before now, and as far as my plea agreement goes, Your Honor, I still have yet to see, review, or even fully consider what that plea is. It should be noted that the pre-sentence investigation report was dated 11 days prior at 8:32 a.m. on March 11th. It was stamped for the Novo County Circuit Court the next day, March 12th at 1:40 p.m. Again, I saw it for the first time approximately 26 hours ago, and I still haven't seen my plea agreement. Your Honor, the evidence in my PSR, Your Honor, between the evidence in my PSR, there are already many details for you to consider in my sentencing. I would humbly ask you to take these facts into account as well. Eddie Eugene Jennings is a dad who always kept pictures of his children in his wallet. The dad who taught his kids how to fish. The dad who created a custom YouTube channel of bedtime stories he wrote and recorded just for them so they could sleep better. The dad who cooked all their meals for them to make sure they ate healthy. The dad who would play with them, whose best part of his day was making them laugh. The dad who raised his oldest stepson on his own from a very young age. The dad who sacrificed his wants, needs, and dreams for years to fulfill his greatest lifelong dream, to be the dad he never had. I love my family more than my own life. To my family, I would like to say I'm sorry for how this has affected and changed your lives. To my 3 children, I love you more than life. And it breaks my heart that I can't be there to watch you all grow up, to cook for you, to goof around with you on our pancake Saturdays, to take you all on beach days, and to be there for all your major life events. You deserve to have your dad present for these, and I'm sorry this happened. To my now ex-wife, you will always be my wife in my heart. I never wanted you to go through this without us being on each other's side. I'm sorry we're not going to spend our twilight years together like we planned. I love you. You're my heart and soul. In the life after this, I hope we can find each other so I can prove to you the man I know I am and want to be. My first thought, my only thought after ending up in jail was, how is my family going to afford propane and how will they eat without my income? I worry about you all and pray for you every day. I love you with my whole soul. I'm truly sorry for how this hurt you all. Your Honor, Mr. Gray has been right about one thing out of all this, and that is the fact that I am not the kind of father to put his family through a trial. In fact, I love my family so much that the idea of putting them through the stress, trauma, and embarrassment of a very public trial was unimaginable. I lost everything in the last 5 months except my mom and sister. I lost my family, my wife, and soulmate, my best friends, my job, my house, my dogs, my dream, and my freedom. But
And if the allegations are true, good. It means the justice system works.
all that is incomparable to what my family lost. While Nuevo County Jail's mental health program are limited, I have found great comfort and purpose. I attended weekly church services with the chaplains. As our PAWS Bible-based Christ-focused fellowship group, Your Honor, whatever you decide for me today, I beg of you not only for mercy and sentencings, but that where I am sent is someplace where I will be safe and have access not only to the kind of spiritual growth I've begun, but also quality mental health care and treatment that will contribute to the rehabilitation I know I am capable of. Your Honor, throughout this process, I felt helpless and hopeless. Thankfully, with the help of Jesus, I have gone for forgiveness and redemption of my soul. I just want a record to show that at no point in the unfortunate life-altering situation do I feel like I've had an advocate in my corner. While the rest of my life was on the line, I don't feel like this has been taken very seriously, but to me, Your Honor, the rest of my life means everything. Today, I'm asking you for mercy, that I have the opportunity for redemption for my life and my family, that I may one day earn the chance to be free again and be able to prove my worth to my community again. Even as I wrote this, my hands were shaking. I'm absolutely petrified of what prison will do to me. With institutionalization, of retribution for the statement, over never seeing my family again, and terrified of dying in prison. I am deeply remorseful over the situation and ashamed of these charges, and again, I pray for mercy. Thank you for hearing me out today. Regardless of what happens today, God bless you, Your Honor. God bless the prosecuting attorney and everyone involved in the investigation, everyone involved in empowering my daughter, and God bless Mr. Greer as well.
Thank you, sir.
Your Honor, may I respond? You might need to have a different lawyer. This is all new to me. Totally new to me. And I think the court is aware of, mandatory 25 years. We went through his confessions, and I guess I'd leave that up to the court.
All right, Ms. Robinson, any additions, corrections, or challenges?
No additions, corrections, or challenges, Your Honor.
Anything that you want the court to consider?
Your Honor, I don't understand what the defendant is talking about when he says he hasn't seen the plea agreement. He was in court twice. I was here personally on January 26th and February 9th. I put on the record the same plea agreement both those times, that he would plead to counts 1 and 3. We would dismiss the balance and we would not seek a consecutive sentence.
I can
It
clarify.
is my turn.
Oh, sorry, man.
He indicates to the court, what a great dad he is. He's also the kind of dad that draws a picture of how far into his daughter, his penis went. So, Your Honor, I would ask the court to follow the plea agreement in sentencing. However, based on the things that were said today, I have very extreme concerns about claims of appeal. He's clearly setting himself up for that. It has already been, this case has been going for a while. I know as well as the court does how long that appeals process takes right now. And the thought of this coming back to a trial in 3 years when the appellate attorneys get around to it, Your Honor, that's not fair to the victim. So the defendant is unhappy with this. I would ask that the court allow him to withdraw his plea. We will remove the offer and he can have a different attorney if the court thinks that's appropriate.
Withdraw the plea? Oh, sir, that is not good for you.
All right, so Mr. Jennings, so the prosecutor is indicating that although there is no, and I do the same thing in every case. I do what the law requires. I read you those charges, read you the maximum penalties. I asked you if you understood the charge, asked you if you understood the penalties. I asked you if you had the opportunity to discuss your case with Mr. Greer. Yep, I confirmed with you that you knew what the plea agreement was. So that was at the time we took your plea. That same plea agreement was put on the record on January 26th. So I am convinced that you knew what the plea agreement was. It made your choice about it. But I guess this might be a situation where you might be careful what you ask for. The prosecutor says that she would not oppose if you want to withdraw your plea. But what that means is you're starting back at square one with the potential for more charges and consecutive sentencing if you're convicted at a trial. So
What I mean to say, sir, and I do apologize, is I don't know, like, because because I'm just learning, this is all new to me. This is all like, not the plea, the statement is, but I'm saying being in court and being in jail and things like that, I'm learning the judicial process is all new to me. So because I have federal people in my cell, they have a plea that they sign and they go over and they read all this stuff. I don't know if that's the same as in state court. So if it's not the same and it's not something I look at and I sign and that's good, then I hear the plea, I hear what it was, and I do understand.
yeah, we put it on the record. Some courts, some counties, sometimes the federal, they put it in writing. I say I do it better. I put it on the record.
Okay.
It's an official transcript.
Okay.
And I go over it with you and
Okay.
ask you if you understand it and ask you if you had a sufficient time to talk with your attorney about it.
Okay.
But
Your Honor, if I may,
hang on, even if that's the case, if you want to start over from square one, you
I
can
don't
do
want
it.
to start over with swear my heart.
All right. So then the other thing is, anyways, you wanted to say something?
well, Your Honor, I've been doing this for a while, as is my experience. I don't mail those police reports and these PSIs to my client. He took it yesterday. I was there to go over it with him. There's a reason I don't do that, because inmates steal these things and then they're out there for everybody to read. It's not safe. And I told him that. I spent time. He went, I arranged to have him there to read the PSI. Not the PSI, the police reports, because they're quite graphic. We went through the law of he took a polygraph, he confessed at the polygraph, and he signed the Miranda rights. Everyone, okay. I don't understand what he's saying, other than he wants to throw somebody under the bus and not take its responsibility. I wouldn't do anything different for anyone else. He's not getting that police report. I'll be happy to mail him to him in prison if that's what he wants. I'm doing it for his benefit. I'm sorry, Your Honor. He completely caught me off guard with this. Never once did he let me know that he wasn't satisfied. Not once. Not once.
So what do you want to do, Mr. Jennings? Do you want to continue on with sentencing today, or do you want to start over?
I want to continue on with sentencing today.
I can tell you, don't let those guys in the cell, they'll fill your head full of crap. I mean, never listen to a jailhouse lawyer because they're already in jail.
That's a fair point.
At least he got him to admit it. Never listen to a jailhouse lawyer because they're already in jail. Well, that's a fair point. Duh, dummy. It's something you didn't consider previously?
Your Honor, may I just put on the record that the victim's mother is here and she has indicated to me that she does not wish to speak. So that she did have the opportunity to do so, but
Okay.
No statement will be made at this time.
All right, we're dealing with 2 counts of criminal sexual conduct in the first degree. The court recognizes it. The advisory guidelines would suggest a sentence between 135 months and 225 months for both counts. The court's going to exercise my discretion, sentence consistent with the plea agreement and consistent with the mandatory minimum here. So it would be the sentence of the court that this defendant served 25 years on the minimum to a maximum of 60 years with the Michigan Department of Corrections. He'd get credit for 144 days that he's already served. Count two, same sentence, 25 years of mandatory minimum to a maximum of 60 years, credit for 144 days. Count one and count two would run concurrent with each other. There is a $68 state cost assessment, a $50 DNA fee, $130 crime victims' rights fund fee, and restitution in the amount of $3,300 to Regina Jennings. He's also going to be required to register as a sex offender, and he's subject to lifetime electronic monitoring. The court would order that these financial assessments would be collected through the inmate account and parole process. And Mr. Jennings, you do have the right to make applications for leave to appeal your conviction and sentence. If you cannot afford it, from the court appointed attorney to represent you on the appeal, request for a lawyer must be filed with the court within 42 days. Now, the opportunities for you counseling and stuff like that in jail. And I can just tell you from past experience in reviewing decisions for parole, if you continue to say, if that's what you're saying is that you didn't do this, that you don't accept responsibility, you will not get parole. They will keep you there. So,
Thank you for your advice.
so, you know, you enter into no contest plea, so I'm not going to talk to you anymore about that. I'm just saying that if you want to have the chance of, you got to get with the program down there. You got to admit what you did and all that sort of stuff. If you don't, there's nothing there for it.
Thank you for your advice on it, Your Honor.
We all know what he's doing. He's trying to set up his appeal for ineffective counsel. Trying to say, I've been alone in this. My attorney hasn't helped me. The PSI was done and it sat for 11 days before I got to review it. I wanted to take this to trial, and he said, you're not the kind of man that would do that to his child. Unfortunately, Mr. Attorney, he is. Because he's the kind of man that did that in the first place for the need for this to go to trial. So, of course, he would have no qualms about putting his kid through a trial. He is ridiculous. And I don't even care if they freeze him before they throw him in the wood chipper. It's cleaner if they do. But you know what? Haste is key at this point.
And Mr. West, can you hear me?
Yes, sir.
Do you have video?
I do not.
Okay, this is file 26005-8SD, People of the State of Michigan versus Christopher West. And if I can start with appearances, beginning with you, Mr. Rad.
Nicholas Rad, Assistant Prosecutor for Allegan County.
Sam Badger appearing on behalf of Mr. West.
Mr. West, please state your full name for the record.
Christopher Donald West.
Thank you, sir. Well, we are here today for sentencing in reference to a charge of operating while intoxicated. The court accepted Mr. West's plea on February 24, 2026. I ordered a PSI and impaired driving assessment screen. The court received those documents. Did you receive those, Mr. Brad?
Yes, I did.
Mr. Badger, did you receive those as well?
Yes, I did, and I've reviewed those with my client as well, Your Honor.
Thank you. Mr. Badger, are you ready to proceed? I'm sorry, Mr. Rad, are you ready to proceed?
I am, Your Honor, yes.
Okay, please proceed.
Pursuant to the plea agreement between the people and Mr. West, we would be recommending no jail, fines and costs, and probation of 6 months, and with counseling as well. Thank you, Your Honor.
Thank you, Mr. Rad. Mr. Badger, your position.
Thank you, Your Honor. We would like to remind the court that operating while intoxicated is not considered a serious misdemeanor under MCL 780.811.
How? How is it not considered a serious misdemeanor? Operating while intoxicated? That is definitely a serious misdemeanor. And I'm from Wisconsin.
And therefore, the legislature has enacted a presumption under MCL 769.5 that this court sentence Mr. West to a non-jail or non-probationary sentence. As I stated earlier, I have received the PSI and IDA and reviewed both with my client. And we would like to note that the supervision level in the IDA is categorized as medium. And further, Mr. West's AOD involvement is scored at a 3 out of 28, and his legal nonconformity is scored at a 1 out of 18, which are both pretty low scores. He also scored a 7 out of 15 on acceptance and motivation, and his DRSE was scored at a 17 out of 61, which both indicate a willingness and motivation to overcome alcohol issues and a low risk of recidivism. Mr. West has reflected on the situation and understands what has gone wrong and what must change going forward. He takes care of his father full-time, who has stage 4 cancer, as well as he takes care of his 2 children. And he realizes that he needs some help, and so we would ask that this court sentence Mr. West to probation with eligibility for early discharge, because Mr. West wants the help and resources that probation provides in his alcohol recovery. Thank you, Your Honor.
Thank you, Mr. Badger. Mr. West, what would you like the court to be aware of?
He is actually pretty clear when it comes to that.
Okay.
Yeah, I mean, that's what I do. I take care of my dad, the kids, I want to get back to work, but, I got to get to the point where if he's going to have to get to a home or something like that. So right now, yeah, I'm just fighting on that, and I do want to get better. I want to help myself, and I'll go through probation. If I got to go AA, I'll do that too.
All right. Well, Mr. West, I want to help you get on track here. And you have a prior alcohol conviction from 2013 that was impaired. This situation, your blood alcohol level was either a 0.27 or a 0.26, but in any event, it was quite high. You were over 3 times the legal limit.
And he drove. And that's not a serious misdemeanor? What if he got into an accident? What if there just happened to be a mother with a small child in the back seat on their way home?
And there was an accident. And you had a passenger, so it sounds as though you're engaged in some behavior that kind of distracted you while you're driving with your passenger also. So I probably don't need to tell you that you should not be engaging in that type of behavior while you're driving a vehicle. If you're going to be doing something like that, at least park the car and be someplace private where you're going to be doing things like that, not be driving down a public roadway where it's going to be distracting you.
Oh, good golly, Miss Molly. So we have 3 times the legal limit with a passenger getting roadhead. causing an accident. But it's okay, guys. It's not a serious misdemeanor. He wants to be better. Low chance of recidivism. With any luck, just for the S content part.
Does that sound like pretty common sense, Mr.
Yes,
West?
Your Honor. Yes.
Okay.
I know I
and
messed
also,
up.
when you're consuming alcohol, just don't get behind the wheel. That's number one.
Yes,
But this,
the big mess up.
yeah, well, this PSI indicates that you consumed a 12-pack of beer and that you're a daily drinker. And I think that you really need to start changing how you're thinking about your relationship with alcohol and its point in your life, and if it's helped you at all, or if it's only gotten you in trouble. And if it's only
Yeah,
gotten you
I'm
in
not.
trouble,
I'm
maybe
changing
you
all
try
that.
to eliminate it from your life because it's not
Yes.
helping you be successful. So what we're going to do here, Mr. West, is we're going to order 1 year of probation. And while you're on probation, you may not use any alcohol, marijuana, illegal drugs, or other intoxicating substances, and you can be tested randomly. I'm ordering a victim impact panel. While you're on probation, I want you to address alcohol, controlled substances, and relapse prevention. Counseling will be as directed by your agent. For the first 30 days, you're going to start on a scram monitor. That means that if you consume alcohol, you're going to be back before me for a violation. I will indicate that there's potential for early discharge at the halfway point of probation if you are successful and have all your fines, costs, and restitution paid off. Your fine is $300. Your state costs are $50. Other statutory costs are $400. There's a crime victim right fee of $75. Those fines and costs total $825. There's a $100 fee for the impaired driving assessment, and there's a $360 oversight fee for probation.
Okay.
This is a total of $1,285. I'm going to indicate that this is due within 90 days. If you need additional time, work out the payment plan. But in order to get off probation early, you have to have fines, costs paid off, and no violations. Does that all make sense?
Yes, Your Honor.
I'm going to caution you that a third offense of drunk driving or impaired, anything involving alcohol and driving is treated as a felony. And that means that you could go to prison for up to 5 years if you were to get in trouble again. I hope that doesn't happen for you. What's the phone number for you, Mr. West?
269.
All right, probation will be reaching out to you. Make sure you have your phone and that's charged up. Is there anything additional on that file, Mr. Rad?
I have nothing further, Your Honor. Thank you.
Mr. Badger, anything additional?
Nothing additional, Your Honor. Thank you.
You're all set, Mr. West. Thank you.
All right. Have a good day, sir.
You too.
He wasn't getting roadhead. He was just, like when you get bit by a snake, you have them suck the venom out. That's all he was doing.
Good afternoon, Mr. Caldwell. Can you hear me fine?
Yes, I can. Good afternoon.
Thank you, Ms. Benson. Can you hear me as well? This is file 260413SD, People of the State of Michigan versus Catherine Benson. If I can get appearances beginning with you, Mr. Rad.
Nicholas Rad, Assistant Prosecutor for Allegan County.
Mark Caldwell on behalf of Ms. Benson.
And Ms. Benson, please say your full name for the record.
Catherine Marie Benson.
Thank you, Ms. Benson. We're here today for sentencing. The court accepted your plea on February 27, 2026, to a charge of operating while intoxicated. I set this matter for sentencing on today's day. I ordered a PSI and impaired driving assessment. I've received those documents. Mr. Rad, did you receive the PSI?
Yes, I did, Your Honor.
And Mr. Caldwell, did you receive that as well?
Yeah, we just received it an hour ago.
Yes, I just got mine late yesterday. So have you had a chance to review that, Mr. Caldwell? And are you prepared to move ahead with sentencing?
I have, there's no additions or corrections, and we are prepared to move ahead.
Okay. For sentencing purposes, Mr. Rad.
Thank you, Your Honor. Pursuant to the plea agreement between the people and Ms. Benson, Ms. Benson will plead guilty to an amended charge of OWI first, and we will recommend no jail, only fines and costs, and probation as well. Thank you.
Thank you, Mr. Caldwell. Your position, sir?
So like I said, I just reviewed it. I don't know if the PSI writer had knowledge that she had already completed the 4-hour highway safety seminar, as well as the 1-hour victim impact panel. I do believe that possibly the scram may be because she did have a prior, but it was in 2011. Here there was no accident. Her car ran out of gas. The reason why I'm talking about the scram is, as you can see from the PSI, my client is a yoga instructor and she owns her own yoga studio. I just don't know the optics of her trying to teach a class with a scram alcohol monitoring device on her ankle. I think that it would hurt her business. And for those reasons, I would ask that you follow the recommendation except for the 30-day scram.
Okay. Thank you, Mr. Caldwell. Ms. Benson, do you have anything to add in addition to what I heard from your attorney?
No, it's already very shameful, and he's right. That would not be good optics. And I teach classes all over the community, not just in my studio. So I'm out there in a lot of like community settings, and I think it's gonna look bad for me, and it's already really shameful enough. I'm sitting here with y'all.
Yeah, and I understand that, Ms. Benson. I appreciate hearing from you, and I can understand why you would feel some shame for being back here on another alcohol offense. My concern is for you and the community and the safety at large. And this isn't your first offense. It's your second, and the alcohol test was at a 0.172. So that's at the super drunk level. And if you were to pick up another alcohol offense at any point in your life, that will be a felony. And a felony means that you could go to prison. So I always hope something positive comes out of these types of situations. And you're in a situation where you can impact other people. And you can talk about your experiences and hopefully cause people to reflect a little bit.
Uh-oh. Probably not a good thing for you that the judge is looking at the alternative good of the optics.
As a yogi, I would assume that you're about mindfulness and about being healthy and being one with yourself and being grounded and all of those other terms that my wife uses with me because she does yoga and I don't. But if you could positively influence someone else, I think that would be something that could be beneficial for you. And I understand that things may be uncomfortable for you, but I I don't want this to be something that's going to be easy for you either. I want you to think on this, and you are someone who should know better. Okay?
Yeah.
You're employed full-time, you're a college graduate, you're married, you have a lot of things going for you in your life. You've been through this whole process before. I'm not going to put you in jail. Okay? You know that you could go to jail on this, right?
Yeah.
And I
Yeah.
could also place you on probation for up to 2 years.
Yeah.
I'm going to give you some breaks, but I am not going to have no scram be one of them. I think that that is going to be something. Yes, Mr. Caldwell?
Would you be open to a remote breath unit such as the smart what is
Smart
what
Start.
it's called, but the one that you blow in with a Bluetooth? Yeah.
The interlock device, I think that that would be much more
Well,
intrusive.
there's a remote, no, it doesn't go in your car. It's a remote device that connects Bluetooth to your phone, and then you blow into it and it takes a photo of you.
Okay, I like the blow and go, or I can't remember the exact name on
Yeah, but it's
that.
not an,
No, that's what the last guy was attempting.
Well,
it's not in a,
this is what I was thinking
not a
about
car.
doing. And I want to hear from Ms. Benson on what she would like to do here. Okay. And again, I think that that would be an opportunity for you to possibly have a positive impact on someone if they were to say, hey, what is that device on your ankle? And then you could have a legitimate conversation with somebody and let them know how there are real world consequences for actions.
Or you could let them know how mean the court system is and you know, tell them what a victim you are.
Right? I see that as something positive that you could take out of this. I see you also being pretty upset about this, Ms. Hall.
Well,
Ms. Benson. But what I was thinking about doing was placing you on probation for 12 months with early discharge. So that means that you could get off probation in as soon as 6 months if you are otherwise successful with all terms of probation. But that was with me placing you on probation, on the scram for the first initial 30 days. Tell me what your thoughts are on that.
I mean, I appreciate what you're saying about using this as a teaching tool for others and also publicly holding myself accountable. I've been thinking on that for like weeks ever since this incident happened, because that's how my mind works. You know, I was hoping, I would love to serve that in that capacity by like teaching a community accessible, inclusive yoga series at like the local Al-Anon club or recovery group, or even facilitating that at my studio as something that was allowing me to use my skills and actually like impact the community with like a series of yoga classes in that type of setting. But that's very far off from a scram editor. Those are two totally different things, like apples and oranges. It's just, I just wanted to say that to demonstrate that I do look at things in a way where I would like to use my skills to pay back the community in a way that's like meaningful and intentional like that. But just letting you know that's what I, you know, think on.
But I think what he's saying is, would you rather do more probation and not have a scram, or do the scram and only do 12 months of probation with possibility of early discharge at 6?
Can I ask a silly question? Because I'm kind of naive about this stuff. Is the scram like still like, is that like a big tether like box? I mean, is it like a big box on my ankle, or what is that like?
It's like a pager.
Well, yeah, it's attached to your ankle,
Yeah,
and you can't take it off. It's,
right.
you know, it's bigger than an iWatch, and it's not as big as, you know, I mean, it's something that's attached to you. You wouldn't be able to wear ski boots while you have it on.
Okay. Oh, okay. This is silly, so I don't want to waste any more time. I would rather have the scram for 30 days, right? Is that what it is?
Yeah, yeah.
Oh, okay, and less probation
Okay.
and get this all behind me and do it that way.
And I
And-
appreciate that. And, you know, I'm willing to listen. And, you know, if it's something that you felt very strongly about one way or the other, Ms. Benson, I'm willing to trade in one direction. But again, I think that there do have to be consequences. And if one person is like, oh my gosh, Ms. Benson, I don't want to have to go through that. That's going to cause me to make a better choice. I think that is beneficial,
I
right?
get that. Yeah, I got it. I understand that.
So what we're going to do is it's going to be 12 months of probation, and while you're on probation, you may not use any alcohol, marijuana, illegal drugs, or other intoxicating substances, can be tested randomly. There's potential for early discharge at the halfway point if you have your fines costs paid off and no violations. While you're on probation, I want you to address alcohol and controlled substance usage through education and prevention. Counseling will be as directed by your agent. For the first 30 days, you will be wearing a scram monitor. There is a fine of $300, state costs of $50. Other statutory costs are $400. There's a crime victim right fee of $75. Those fines and costs total $825. There is a $100 substance screening fee and then the oversight is $360. So fines, costs, probation, and the IDA total $1,285. And that will be due within 90 days. If you need additional time, work with your probation agent. I need a phone number for you, Miss Benson, so that probation can reach out to you.
Okay, 616.
Okay. Now, I do hope that you are able to move forward from this in a positive way, and I hope that this is the last time you get in trouble for something like this, Ms. Benson.
Oh yeah, it will be.
All right, anything additional, Mr. Rad?
Nothing further, Your Honor. Thank you.
A call the case. This matter is entitled People of the State of Michigan versus William E. Benz.
This one, Jerry said I had to run it. I told you we get 2 wood chipper folks tonight. This is the other one.
File number is 2425114FC. This is a 45th Circuit Court matter. Mr. Benz started this journey in the district court several years ago in front of Judge Pattison, and the matter was bound over to circuit court on a waiver charge, on a waiver or preliminary examination. My name is Judge Jeffrey Middleton. I'm here by special assignment on behalf of Judge Paul Stutzman. Mr. Stutzman, Judge Stutzman has announced that he is undergoing a course of cancer treatment, hopes to complete the treatment and return to full service, but for the time being, we will be filling in for these kinds of things. I am cross-sworn, all 4 of us are cross-sworn to handle assignments for one another, and several times a year I'm called upon to do a circuit court matter. So you have me. What we have here is a motion by the people to revoke bond in this case. The people are represented by Alicia Gallagher. Am I saying that correctly?
Alicia Gallagher, Your Honor.
Elish?
Alicia, yes.
Alicia. All right. Alicia Gallagher is here from the Attorney General's office. Luke Knopfinger is here on behalf of the defendant and Ross Truckee as co-counsel in this matter.
This matter was assigned to the Attorney General's office during Prosecutor Marvin's term. He asked the Attorney General for assistance in multiple criminal sexual conduct cases, maybe 6. This is one of those. It precedes Prosecutor Davis's tenure, but plaintiff people are represented by the Attorney General. Mr. Benz was originally charged in the district court file number 231412. Charges are serious. It's alleged that he did engage in sexual penetration with a child under 13 years of age. 2 counts. That is a felony punishable by up to life imprisonment. He was also charged a 3rd count and a 4th count. And he was also charged as a 4th habitual felony offender, requiring a mandatory 25-year sentence if the defendant were convicted of any of these counts. The matter was bound over in 2024, I think, in front of Judge Pattison. And the matter, it's embarrassing to me, frankly, that this case is a 2023 case and we're here in 2026 and it's still pending, but I don't have any control over that. All right, Mr. Benz, you okay? No. Well, I got the Kleenexes there. Yeah, serious charges, serious ramifications of a conviction. The prosecutor, through the Attorney General's office, has moved to revoke your bond. And they filed a pleading with a number of exhibits attached. Ms. Gallagher, I probably known Mr. Benz myself for 20 years or more.
I got my wife is right there. That's who the
All right,
that was on.
that's a good. All right, so why don't you state for the record the people's reasons for requesting to cancel the bond?
Thank you, Your Honor. For the record, and I did lay out some of it in my motion, but specifically, and I guess most troubling to me is that when defendant was on bond, he was being monitored by a tether. This was after multiple times that his bond had been revoked. There was a period of absconding, and that's laid out in the people's motion. However, this charge on November 26th of 2025 in Kalamazoo County was for violence against a female, an intimate partner. They did charge a domestic violence 3rd case on this case. Due to committing violence against a significant partner, he was able to get out of the tether. And then when he was released, never again was subject to tether monitoring. Your Honor, interestingly, when we look at
so what you mean is he went into custody and they took the tether off while he was in custody in Kalamazoo County. Is that correct?
Yeah. Correct.
Okay.
And let him leave Kalamazoo County without putting the tether back on, with the understanding he was going to get the tether put back on, and never did.
Right, well, let me stop you for a minute, just for the record. Did the Kalamazoo County case result in a conviction?
No.
It did not, Your Honor. From lack of participation, they decided to follow the victim's wishes. However, I did notice in my other acts notice, and I did get the video surveillance and body cams that I've shared with defense from Kalamazoo County, and some of the assaults of nature that was on video from that domestic violence 3rd charge. That did not result in a conviction.
Okay, go ahead.
Thank you, Your Honor. Notably, in the report from pretrial supervision, it says that when he was on the device, there were no violations. However, respectfully, I would think that, you know, the assault of charge would be a violation of bond, which he apparently did while on the tether. So it does not seem that the tether was enough to stop any kind of assault of behavior with significant others. Further, Your Honor, the defendant's history of not only failing to appear, but also his history with drug use, and documented convictions for aggravated assault, assault and batteries, attempt, resisting and obstructing, a slew of disturbing the peace, but more importantly or more troubling, multiple dismissed domestic violence cases, and also 2 that remain a conviction pled down from a strangulation case. As your honor is aware, this is a very serious crime, and being on any type of bond and in the community is a privilege with regards to when you are charged with a criminal sexual conduct in the first degree. I believe that this defendant has shown that he is not able to be in the community with any kind of supervision that would protect the public and adequately assure that he is appearing for court. Further, not only was the tether not placed back on, but the pretrial service report indicates multiple attempts of contact were made and no phone calls were returned. He had not been even checking in as required. And
I think that this is partly a failure of Kalamazoo County. Why did they remove the tether and then not replace it?
then we did get an updated report that said on 3/4 of 2026, he stated he didn't have a working phone and is homeless. It's not setting up ideal situations. If he can't, remain on tether and have the rest of the public safe, I just think it's not appropriate at this point. And we'd ask for his bond to be canceled. Thank you.
Are you referring to the report from our community corrections coordinator, Tiffany Howe? From earlier this month in March, is that correct?
There was one from report dated March 6th of 2026, Your Honor. There was also one dated report January 28th of 2026. I believe I attached the January report as exhibit 2 to my bond motion.
Well, the more recent one you referred to, March 6th.
Yes.
Is, doesn't say who authored it, but Tiffany Howe. Where you indicated he did contact the office on Wednesday, March 4th. He does not currently have a working phone and is homeless. He's been staying at the shelter. All right, thank you. That's, I think, in the file as an exhibit. Who's going to speak on behalf of Mr. Benz?
I can make a couple comments, Judge, and then ask Mr. Truckee to maybe play cleanup here. A couple things is the case was dismissed in Kalamazoo. Just yesterday, the day before, I did receive a lot of body cam footage. I didn't have the surveillance footage to review repeatedly throughout the case. And, this is kind of awkward relitigating maybe a domestic violence that was dismissed, but Mr. Ben's very clear. He says he was assaulted first and it was in response to that. Haven't had an opportunity to review that surveillance footage. He did spend 30 days in jail because of that case.
Oh, I only whooped her because I got hit first. Love that.
Kind of interestingly too, I'd note too that Tiffany Howe does say that the electronic monitoring, I guess there's some attempt to have him placed back on the GPS monitoring. But then at the end of her report, she said it is not considered best practice to maintain an individual on GPS monitoring for an extended period of this length, absent violations or new concerns. I guess maybe that's the violation of the new concern. I don't know. This case has been pending for some time. There was just a 768 notice that we're preparing an objection to filed just recently. I would note, and I think this is important because MCR 6.106 is invoked here, that due to the nature of the charges, the court can deny bond if the presumption is great. That's important, Judge, because, and I don't know how much the court is familiar with the case. I assume there's an affidavit
That's all I do know about it. I didn't handle the case at the district court level. Judge Pattison did. But I have looked at the affidavit of probable cause that accompanies the pleading.
And I would note a couple things in there, Judge. This is a delayed disclosure from 2023 based on allegations in 2015 and 2016. So there are a lot of things going on here. There's a couple protective orders in place. So there are some medical records and some other things I can't really share with the court. But we're litigating those points. So I think what the court would have to find is that the presumption of guilt is great. And then the court would then have to make a finding that the second part of that court rule that either there would be a risk of harm to another individual or the public at large. There was a period of time where Mr. Benz was not making, that he had failed to appear. There have been a litany of status conference, motion hearings, and other things where he has appeared for those things.
I tried to follow the history of this case, and like I said, I'm embarrassed how old this is, but there have been probably more than a dozen court hearings in this matter.
Yeah, that's true, Judge. And underlying all of this too, Judge, is just, well, simple and honest in poverty, right? Where there is someone is living at the homeless shelter, struggling to find secured housing. There have been a long list of phone numbers that have been provided and then been discontinued. So Mr. Benz is here today. He has appeared at numerous court hearings. And there is a difference between, there was a bond that was set. Many of the things stated in the bond motion too were known when the bond was set initially. He was able to post that bond, and now the ask, Judge, is to just throw it out altogether and cancel the bond. Court has a wide range of options before it. I think asking to have the bond canceled is somewhat of an extreme ask given the circumstances. So defer to my colleague. Thank you.
All right, Mr. Truckey's quite eloquent. Let's hear from him too.
Thank you, Your Honor. In response to the state's argument, first, there's a hint that bond is a privilege, and I would object to that consideration. Remaining on bond may be a privilege, but it's also a right that our founding fathers established for us. Mr. Benz posted a bond, and he has attended the vast majority of the court dates. There was an issue in November, I believe. Judge Stutzman heard about that at a status conference earlier this year, and he made his determination on that at that time. This domestic violence investigation was also known at that time. A formal motion, I don't believe, was brought before Judge Stutzman, but this was all in the air at the last status conference. It wasn't a big surprise. And Judge Stutzman allowed Mr. Benz to continue on bond. He's been participating in Ministries with Communities in Kalamazoo. That is a resource he's used to stay in contact with me. He's been in regular contact with me. He's not absconded from the state. He's not disappeared. He wants to continue to litigate this case. It's a complex case with old allegations and again, as Mr. Knopfsinger alluded to, very technical and private details that we may be subject to a protective order. But all we're asking is that Mr. Benz continues doing what Mr. Benz is doing while this case is prosecuted. The domestic violence case was dismissed by the prosecutor in that jurisdiction. I don't have documents saying why. I don't have a declination. I don't have a nollie pros order in front of me. The prosecutor in that jurisdiction elected not to pursue charges after Mr. Benz did spend some time behind bars. Of note, the alleged victim in that matter was also taken into custody on that day and released shortly thereafter. She's here today. Also, there's some conflation. There's a criminal sexual conduct charge against a minor, and I don't want the conflation of between domestic violence charges with intimate partners to kind of bleed over. Those crimes, I suppose they rhyme with each other a little bit, but they're not the same. And so I want the court to make sure to kind of consider them distinctly. But with the age of this case, and frankly, with some of the matters going on in the circuit court, there's a concern I have that this may be victim of delay for reasons outside of any of our control. And I would hate to see Mr. Benz spending a prolonged period in custody awaiting his trial. So that's my piece. I'd ask that you deny the motion. If the court would want to impose further conditions, including electronic monitoring, that's understandable. Mr. Benz is employed, so he does have positive people that are in his life as well, besides just the folks at the drop. But we ask the court to consider those options short of revoking his bond and taking that extreme step of remanding into custody. Thank you.
Mr. Benz, where are you employed?
Through Open Door Construction.
Which is through the homeless shelter?
No, actually, I went out when I first came to Kalamazoo. I went to a temp service and I met a guy that does construction. He has his own business. Just starting out, I helped build the courthouse in Kalamazoo, and I helped build the Raising Cane out on Westmead. He's a commercial contractor. I've been with him. He's actually been with me through this whole thing. I mean, he's, been awesome. Been good. Been my boss.
Then why are you in the homeless shelter?
Just because of the traveling. I don't have a car. I can't. My boss picks me up for work every morning, so I'm just trying to get up on my feet. And with the allegations that are put on me, it's kind of hard when they want to run in my background.
If I gave you a drug test right now, this minute, what would it tell me?
Probably great. For weed.
Yeah, for meth.
You said for weed, right?
Just weed.
He doesn't sound so confident in that answer.
Possibly.
All right.
But I really, that ain't nothing that I have in my.
That's a underlying theme here. Pink elephant in the room. You've been struggling with methamphetamine for a while. Now, this crime allegedly occurred between 2014 and 2016. You've been here multiple times between then and now.
I'm not trying to do anything.
In 2023, I handled file 23653FY, and it was a very unpleasant domestic assault. I believe it was charged as domestic violence. Third offense, it was reduced to a domestic violence, 2 counts.
I don't think I've ever heard of a pleasant domestic assault. Have you guys? Is that a thing? Am I missing something?
You assaulted your partner, Ms. Yoder, and holding her down on the bed, slapping her repeatedly, tearing her clothes off, shoving her down the exterior steps. I gave you 60 days jail in May of 2023. In 2022 to 2023, the interesting thing is you just got out of jail and filed 23419FY. You were charged with possession of methamphetamine and some motor vehicle offenses. Pled to use of methamphetamine. I gave you a huge gift. 13 days credit, 13 days lay out of jail. You were to pay your fines by August 1st, which you paid 0 of. When it came time to posting a $15,000 bond, you had money. When it came time to paying your court fines and costs, you don't do so good. You have $2,059.32 worth of unpaid fines and costs. That methamphetamine case that I gave you a break on, you paid none. Malicious destruction of a building, $497. Careless use of a snowmobile, I remember that one, $192, and a bunch of traffic stuff. So, all right, I let you out in March. In April, you beat up Miss Yoder and you go to jail for 60 days. In May of 2023, I think you got out sometime in June. Then this case was charged in July of 2023 is when the trooper signed it. So I'm not sure exactly when you got arrested. Although let's take a look at that. I have the bond. So you went to jail in March, you went to jail in April, and then you got arrested on this in July, I think.
The instant case arrest would have been in late November, early December of
24. I'm looking for the bond form. I had it. The defendant had failed to appear a couple of times. Frankly, I was surprised that he posted the $15,000 bond. It was set by Magistrate Autumn Kiefer. And the defendant did post it. Then it got revoked maybe twice. I had the bond. You're not doing better, Mr. Benz. I suspect if I gave you a drug test right now, it would show positive for methamphetamine, and you acknowledge it would be positive for marijuana. You got some indeterminate job and you're living in the homeless shelter.
I'd be willing to wager that his bond said no drugs or alcohol, including marijuana. I would be willing to put money on it.
This is not a matter of ensuring that you show up for court. It's a matter of protection of the public.
Just domestic that I had.
All right, well, just your lawyers don't want you to just say things at random. Here's the bond. All right, it was set the amount of $15,000 cash or surety. And it has a number of conditions which are on every bond, and they added some. The conditions of your bond are as follows. These are printed right on the back. Make reports to the court agency as specified by the court or the agency, which would include, we don't normally eat or drink while we're in court. So I'd ask you to leave the coffee set aside. We'll pretend like we're in a real hearing.
Apologies, sir.
Make reports to a court agency as specified by the court or the agency, which that would include the reporting to community corrections, which right now is off the rails. Not use alcohol or illicitly use any controlled substance. Participate in a substance abuse testing and monitoring program. That was not ordered, but if it was, they ordered 2, 5, 8, and 9. So not use any drugs, comply with the restrictions on personal association of place, residence, or place of employment. Not to.
I have never heard a judge tell someone not to drink during a hearing. I've never heard that. That's the first. I've heard don't eat. I mean, that's just a given. But put the coffee down? Judge Middleton, you monster.
Have any contact with the complaining witness. Condition 8, continue to seek employment. Condition 9, continue to begin educational appointments. The bond also says you shall not harass, intimidate, beat, molest, wound, stalk, or threaten to engage any conduct that would place any of the people in danger, specifically those people. This is the terms and conditions of the community corrections supervision. I will personally appear for any examination, arraignment, trial, or sentencing. Will appear at such times and places as may be directed by the district court or the circuit court. If I am represented by an attorney in this case, any notice to appear may be given by my attorney in place of personal notice to me. I will abide by any judgment entered in this case and will surrender myself to serve any sentence imposed. I will not leave the state of Michigan without permission of the court having jurisdiction over my case if I am on a felony bond. I will not commit any crime while released. I shall immediately notify in writing the court having jurisdiction over my case of any change in my address or telephone number. I will abide by any other conditions described in the face of this form. I understand if I violate conditions 12 or 13, I am subject to arrest without a warrant and may have my bond forfeited or revoked and new conditions of release imposed. Now, the conditions 12 and 13 are not assault, harass, intimidate, beat, molest, wound, or threaten any named person or persons on the face of the bond. And 14 is satisfy any injunctive order. Now, the person that you allegedly molested, beat, or wounded was not a person named in the complaint. But I understand that if I violate any of the terms and conditions of this bond, I will waive extradition.
I mean, really, do they have to name every person? I kind of like the ones that just say, don't do it at all, or just don't violate the law. I mean, that pretty much puts a blanket coverage all across the bond.
If I'm arrested in another state. So you got arrested for a domestic assault. I wasn't clear if the Kalamazoo charge was a felony or a misdemeanor. You do have several previous assaultive charges here, including the one I gave you 60 days for, which I frankly thought that was a gift. Then just before that, I'd given you 13 days, which was a gift. The statute referred to, or the court rule, which is 6.106, it deals with pretrial release. Now, one of the issues here, this is a serious charge. This is a capital offense, 4 counts of criminal sexual conduct, first degree, which is punishable by up to life imprisonment. It's not breaking into somebody's shed in the backyard. It is a capital offense as a 4th habitual offender. So you take into account the actual nature of the charge. 6.106B, 1B, a defendant charged with criminal sexual conduct in the first degree, which is this.
Is it just me, or did Judge Middleton deliberately make shed pronounced like shit? I think he did it on purpose.
Armed robbery or kidnapping, if the court finds that proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. I don't think you're likely to flee, but I'm not sure I've got clear and convincing evidence that you're not going to be a danger to any other person. Just before you got arrested for this, you seriously beat up your previous girlfriend. And I gave you 60 days in jail. A while later in the same year, you got arrested for this charge. It is true that you have not been convicted of the assault charge in Kalamazoo. To be convicted of that charge requires proof beyond a reasonable doubt. And for reasons that probably were apparent to Kalamazoo County, sounds like they had lack of cooperation. They dismissed the case after 30 days in jail. The victim was Catherine Gartner, also known as Catherine Louise Gartner. Is that you?
Yes, sir.
Or you refer to her as your wife? You're not married.
No, no.
All right. She apparently isn't very concerned about it, but what you told the officers was on the body camera, you think I assaulted someone today, just wait till I get out. I'm gonna get out tomorrow on this bullshit charge, and I'm gonna be back on the streets tomorrow, and I got something for your bitch ass. I got something for Catherine when I get out tomorrow. I got something for you, you nigger bitch. I'm not convinced by clear and convincing evidence that you're not a danger to other people. I'm embarrassed that you got arrested for a serious domestic assault charge in Kalamazoo while you've been on bond on this case for 2 years, 3 years here in St. Joseph County. I also haven't made a finding that you're positive for drugs. You've acknowledged marijuana, which is lawful for adults for recreational purposes. but I think marijuana is still in the equation. You also failed to re-register and advise the court of your address after you got out of jail. You're not presently on any tether supervision. We don't know what you're doing. You're not being drug tested, and you're living in a homeless shelter in Kalamazoo. And you talk that way to a police officer in Kalamazoo, threatening him, a complaining witness, and not comporting yourself very well while you're on our bond on a criminal sexual conduct charge. Mr. Benz, I won't be the judge to try this case. I'm not sure who will be. I'm not sure if I'll live long enough to see this case go to trial, but I'm canceling your bond. You're out on a capital offense as a fourth habitual offender. You're not in compliance with your tether requirements. You've got $2,000+ of unpaid fines and costs for previous assaultive and drug offenses here in my court. And you talk like that to the police officers. Yes, don't. You're going to jail. Your bond's canceled. A circuit judge can review it for further hearings. And I do apologize because this case is a long way from getting tried.
I would never touch my kid.
All right, well, the fact that you'll never touch any, what did you say, any children? I don't know.
Oh, dear goodness. I promise I'll never touch another kid. Another? Sir, the prosecutor's listening. Another kid. You just admitted. You're going to trial for it, and you just admitted it, you dipshit.
What you said, but don't say anything else. Take him back into custody. His bond is canceled.
I love you, babe.
Judge Middleton, this is set for trial
No,
on April 28th.
say that again.
This is set for trial on April 28th and it's the first
All right,
case to go.
okay. All right, that's Jill Ross from the circuit court.
Okay. Hold on.
Fourth habitual offender. You're not in compliance with your tether requirements. You've got $2,000+ of unpaid fines and costs for previous assaultive and drug offenses here in my court. And you talk like that to the police officers.
I was just angry.
Yes, don't. You're going to jail. Your bond's canceled. A circuit judge can review it for further hearings. And I do apologize because this case is a long way from getting tried.
I would never touch my kid.
All right, well, the fact that you'll never touch any, what did you say, any children? I don't know what you said, but don't say anything else. Take him back into custody. His bond is canceled.
I love you, babe.
Judge Middleton, this is set for trial
No,
on April 28th.
say that again.
This is set for trial on April 28th and it's the first
All
case
right,
to go.
okay. All right, that's Jill Ross from the circuit court. The matter is set for trial for April 28th. So we are really not talking about that far.
Billy, I got you here. I love you, sweetheart. Don't worry, Billy. We'll figure it out.
I thought you had sent me an order canceling the bond, but I couldn't find it.
No.
Did you do one?
You guys didn't even let me see anything on this yet.
We're still on the record, so you guys have a seat for a minute while we finish up and then you can talk. Did you send an order canceling the bond?
Would you like me to do one, Your Honor? Apologies, I did not.
Well, we had an earlier one. Jill, can you do one?
Yes, I can.
All right. For the reasons stated on the record, the bond is canceled. I feel better knowing there's an April 28th trial date. I don't think he's a flight risk, but I'm not convinced that he's not a danger to other members of the public. All right, thank you. We'll prepare the order here by the court.
Appreciate it, Your Honor. Thank you.
All right, thank you.
Apologies again for the drinking, Your Honor.
Well, you
coffee.
didn't know. People tend to just be informal when they're in their office and but that's generally not a good form. All right,
Understood
thank you.
moving
It's
forward.
nice to
Thank
meet
you.
you. And
Thank you.
good luck as this case goes forward. Thank you, gentlemen.
Thank you, Middleton. You said April 28th was the trial.
Wow. I promise I'll never touch another kid while you're going to trial for touching a kid under 13. Yeah, he's a smart one, folks. He deserves every bit of his sentence he has coming, because it's coming. I don't think it will be. This was the 45th. This was the 45th. Judge Simpson is 14A, Washington is 14B. Gauthier is 58th. Sometimes he does 68th, I believe. I don't know. I don't know who's going to have the 45th, but I doubt I'll be able to get it. I'll try, but I doubt it. Oh, absolutely. 100%. I don't know why we don't do it more often and sooner. Some of them do. Some of them do. Heck, I remember when I first started streaming, I looked for circuit court cases all the time. I found them. But they're harder to find now. And sometimes you can find them not on YouTube. Again, it's harder to find now. The courts know I exist. Oh man, you guys know how much work I put into this for you. You guys know that this like consumes me so that I can present the good stuff to you. Of course, I have to memorize silly stuff. I've never seen Judge Ross. I have been seeing new judges lately that I've not seen before, and I have been seeing some old judges that I haven't seen for a long time making an appearance here and there, but it's hard to find. It's hard to catch them because you don't know that they're going to be on, and they don't regularly stream. So, I mean, I have ways, I have methods, but I don't get every one of them. And even setting notifications doesn't work because you don't get all of them, even if you set to get all of them. I can't tell you how many Ricky and Crumb cases I miss because I don't get the notification, but I have it set to notify me of every 13th District Court hearing. YouTube doesn't care. They're like, oh, you want all of them? Here's 13%. I know. Man, how dare I go adulting in life and not get every single case. That does not sound like something I want to run. I was on the fence running this one. And honestly, I watched 3/4 of it. had I watched it, I would have I put a little sound effect over that one word that's probably gonna get me yellow tagged on it. I will try. It's got YouTube has a self-assessment for monetization, and you can let them know that there's inappropriate commentary in it, but that it's not said in a hateful manner, and then they don't get as mad about it. I'll try that. I don't know if it'll work. I'm probably gonna get yellow tagged. It's okay. No, don't be. Don't be. I wanted to stream it. If I didn't want it, Jerry, I don't do this for the money. I do this to spend time with you guys. If I did this for the money, I wouldn't do it. Oh, yeah. Yeah, it's time for them. Oh, you want to see something great? Kitty time. Hold up. Hold up. So I'm always complaining about how Earl comes up and taps my leg because it hurts. So I complain about it a lot. And well, today I posted pictures in Insomniac chat. So for those of you who have not seen it, this is my left leg. This is all from Earl. Those are all tiny little Earl pokes. He comes up and he taps my leg to get my attention. Sometimes a little harder than others. And then you see my right leg above my knee. And that's from Bandit. That's from when I go sit down in the bathroom. Bandit decides to step up on my leg and say hello with her claws. This is why I complain. Yeah, yeah. They're not sexy. No. They're very muscular because they carry, you know, all of this. Crazy, crazy, crazy. That's you. Yeah, yeah. Speaking of which, he was poking my leg the whole time. Like the whole time I was editing and after and during the stream. Billy's up on top sleeping. He's right there. I tried getting Earl to climb the wall earlier. I actually physically took him and placed him on the wall. He hung on like a Garfield stickum. It was great. Mary, I love you. I can tell you're a little ways behind, honey. But just so you know, when you get caught up here, love you. She's adorable. Hey, Ava, where'd you go? Oh, you're on that bed now. I have to bribe you with treats so that you come cheer everybody up. You know what? We haven't opened the... Oh, wait, did we? Oh, we did. We have duck and turkey and then salmon. And there's Ava. There's Ava. There's my baby girl. There's a good girl. Who's a good girl? Who's a good girl? Who's a good girl? Who got the cutest face? Yeah, we know it's you. She got started on a new med today. She was on Simpiacaro, but now she's on, what was it called? Credelio Quattro. They only gave me 1 dose of it. They initially said no to her refill because she's due for her rabies shot, and they'll refill it at that time because they have to also do a heartworm test. It's like she's been on Simpicaro for 6 months now. That treats fleas, ticks, and heartworm. She had a heartworm test before she started it. So logic would dictate that she doesn't have heartworm if the med is effective. But even though they've had her on heartworm meds, they have to do a heartworm test before they can refill the heartworm meds. I know. It doesn't make sense. Ava, your job is to make everybody happy, and you're darn good at it. I need you tonight, 'cause I'm not sleeping. Well, that's boring. I started typing that I wasn't gonna be going live. Okay. I wasn't feeling well. We'll put it that way. So my typing, I'd start typing, I'd get sick, and then I'd return to my phone to 10,000 random characters because I was holding it while I got sick. So then I sat here, erased everything, started typing again, and then I'd fall asleep. And then I'd wake up and get sick. And yeah, Jerry was in Discord monitoring the message the whole time, apparently. All of a sudden I get a message from him. April, you've been typing for 36 minutes. Yep. Yes, I have. And it took me another 15 to respond. Yeah, he was kind of freaking out. Jerry, I fall asleep holding my phone. At least I don't Mortimer Duke things and accidentally ban people. All right, Ava's getting a duck. She's like, about time. You pulled those out a while ago, and I still don't have one in my mouth. There. All right, guys. It's 1:35 a.m. I still have to scoop cat boxes I put them away. I'm sorry. I still have to scoop cat boxes and get my garbage can to the road because tomorrow's garbage. So, yeah. And I need to. He just heard it. I love you. I just had to make sure you were one of the 13 people still watching. Hey man, those are super expensive, and I have 7 litter boxes in this house. 7. I do it all the time, man. I stopped laying on my back and typing or watching videos because I got sick of getting smucked in the face. No, you only see it if it's on my phone because my computer keyboard, for one, is tucked way back, and I don't leave Discord open on the tabs. So, oh man, the cats would get out of there before it ever had the chance. Like my bed, it makes this sound before it starts releasing air pressure. It'll go it'll be like this thunk, and then you feel the air pressure releasing. The moment it starts moving, the cats and Ava just scatter. It's insane. I've had it a couple weeks now, and you would think that they would be used to it. No, they don't like it one bit. They love being on it as long as the auto responsiveness doesn't kick in or the settings don't change, other than the foot warmer. My goodness, they love the foot warmer. Hi, tiny kitten. Thank you so much, Purple Kiv. I will set that aside, and I will start collecting for an auto litter box fund. I won't get one of the spiral ones. I absolutely refuse. Jackson Galaxy actually spoke on those one time, and he pointed out cats are so big on smells. Can you imagine having to go into a tunnel that the entire surface area around you is coated with poo smell or pee smell? So I won't get one of the rotating ones. I would get one of the flat ones that has the little rake that comes across. But with the boys, and now I have 3 of them, boys. With the boys, I have to have high back litter boxes because they don't pee down. They pee straight back. I'll never understand it. I will never understand it. They're not spraying. It's different. Like spray, that when they spray up a wall. And pretty soon, none of them will have the ability to spray. Only one does currently, but Thursday's the day. Oh, yeah, that also happened. I haven't talked about yet. So I was so excited. Monday was get snitch fixed day. Show up to the vet, and you have to call before you go in because they have a tiny office and they don't want too many animals out and about at once. So I call them and they're like, yeah, he's not scheduled to be here till next Monday. I'm like, what are you talking about? I called Friday and confirmed all the details. Y'all told me not to feed him after 6. I didn't feed him after 6. What do you mean next Monday? I can't go another week like this. And they're like, sorry, we would do them today, but we're booked. And I'm just like, oh my gosh. another week? And the lady, thank God, bless her heart, she goes, well, I can work him in Thursday. Now, and mind you, my tone up to this point had been accusatory and blaming, as if they had gotten something wrong, you know. I had very assuredly been told the 23rd. I knew it. It was in my calendar. The 23rd. So after I got off the phone with her, I thanked her profusely for getting us in Thursday. But I did, like, when she was like, do you still want to get him fixed here? I'm like, well, I don't really feel like I have another choice. And I know I sounded bitchy and sarcastic, and I did. I was upset. I didn't Karen out or anything. I was so sure that it was the 23rd, dang it. And the thought of having him in a kennel another week was killing me. Oh my gosh. Longest weekends ever. And I got off the phone and I went back in the messages to the gal that told me to call them in the first place. And it said, yay, they can get snitching on the 30th. And then I realized 23rd wasn't Snitch's appointment. I had a doctor's appointment at 2:30 that day. My ride was picking me up at 12:30. I was also in my calendar. My brain mixed them up. So I called the vet back and I said, I just want to be completely transparent with you. You guys did absolutely nothing wrong. I just went through my text messages, and the day the appointment was scheduled, I specifically said to my friend that you guys could get him in on the 30th. Today is my doctor's appointment, not Snitch's. And I just wanted you guys to know that nobody in your office did anything wrong. Other than when I did call on Friday and confirmed when I should stop feeding him, they didn't verify the appointment time. They just gave me all the info on when to stop feeding him. So it assured me that I was right. But other than that, you guys were right. She's like, okay. I said, is it still okay he comes on Thursday, please? She's like, yes, he can still come on Thursday. Oh, man. Talk about eating crow. I'm sure I did. But Jerry, these things are like 3 hours long. If I had to go back and check the live stream for everything that I said, I'm just gonna not. Unless it comes down to clipping, something where I'm making fun of you and it's hilarious. Lick the spoon, Jerry. Lick the spoon. I don't have one of those. Not on this. I have that on, I have a lift chair, but I don't have it in the house and it's not hooked up, but it's got a massage setting, and a heat setting on the foot, but I don't have that hooked up. It's a double wide and it's really big, and it doesn't have where I can automatically put the feet lever down. So the only option is to use the lift. And it's really slow. And I am not patient. If I have to pee, if I have to get up and run, well, run my version, it's still faster than waiting for the lift. So no, it's on the porch. It's not hooked up. $1,300 freaking chair, massage and heat, and I can't even use it. I can't, because if I have to go to the bathroom, I need to get up a lot quicker than what it does. I don't know. Maybe it does. I didn't look. Maybe it. I don't think it does. Hi, baby. How you doing, baby girl? How's my sweet baby? Mwah. I know. I know. I had to get a Tinder date to bring it in, to bring it from my storage unit to my porch for me. I actually did that. Yep. I went on Tinder just to get somebody to move my furniture. I'm just kidding. No, he was nice enough to do it though, but there was no relationship potential. Hi. How you doing, sweet thing? I love how she jumps up on the back of the chair. Billy jumps up on the back of the chair as well, but he uses me as a step with his claws. So my back kind of looks like the back of my legs. It was covered by my insurance like 7 years ago. It was a long time ago. Yeah, one of my handymans. Yeah. I saw the guy twice. No. I don't even remember that. I don't even remember his name. I just know it wouldn't have worked out. There was absolutely no spark. None. So, yeah. All right, guys. I'm going to take off. I'm going to go scoop cat poop. Because that's what we do around here. 7 boxes to go. 7 boxes of poop on the floor. 7 boxes of poop. Now I'm just procrastinating. Oh, I love you guys so much. I have had an amazing time tonight. Thank you for enjoying tonight with me. Be safe, be well, sleep sweet, and much love.